My name's Ashley Titus. I'm the president of the Sacramento Lawyers Chapter, and I have the pleasure of introducing the moderator of this panel, the Honorable Carlos T. Bea. Judge Bea serves as a judge on the United States Court of Appeals for the Ninth Circuit. He received his bachelor's degree and his JD from Stanford. Judge Bea was born in Spain and immigrated with his family to Cuba in 1939. In 1952, he represented Cuba on the Cuban national basketball team in the Helsinki Olympics. Judge Bea became a naturalized citizen of the United States in 1958. He was nominated by President George W. Bush to the United States Court of Appeals for the Ninth Circuit and was confirmed in 2003. And Judge Bea will introduce the next panel.
Thank you very much, Ashley. I'm very pleased to be here in Simi at the Reagan Library. My name is Carlos Bea, and for my sins, I sit on the Ninth Circuit Court of Appeal. And we're going to discuss about immigration today. You see before you probably the only federal judge who's ever been under a warrant of deportation. I beat it on appeal, otherwise I wouldn't be here, right? We have a distinguished panel to inform us about the conflict between federal and state and local regulation of four subjects. On my far left, only geographically.
No, you've got it about right.
Is John Yu. Professor Yu is the Emanuel Heller Professor of Law and Director of the Korean Law Center, the California Constitution Center, and the Law School's Program in Public Law and Policy. Professor Yu received his BA summa cum laude from Harvard and his JD from Yale Law School, where he was the editor of the articles editor of the Yale Law Journal. Professor Yu then clerked for Justice Clarence Thomas of the Supreme Court and Justice Lawrence Silberman of the D.C. Court of Appeals. From 2001 to 2003, he served as Deputy Assistant Attorney General in the Office of Legal Counsel at the U.S. Department of Justice, where he worked on issues involving foreign policy, national security, and separation of powers. To his right is Professor, we call him Deep Gulasekaram, who is a professor who teaches constitutional law and immigration law at Santa Clara University, and he's been there since 2007. He's co-authored the recent book, The New Immigration Federalism, and he's also written extensively on the relationship between the Second Amendment and immigrants. He was a visiting professor at Stanford Law School and also at NYU, and before doing that, he was a litigation associate at O'Melveny & Myers and Susan Godfrey, both in Los Angeles. He clerked for the Honorable Jack Wiener of the U.S. Circuit Court of Appeal in the Fifth Circuit in New Orleans. To his right is Professor John Eastman, who is the Henry Salvatore Professor of Law and Community Service at Chapman University Fowler School of Law and was the dean there from 2007 to January 2010 when he stepped down to pursue a bid for the California Attorney General position. Professor Eastman is also the senior fellow at Claremont Institute, and he also clerked for Justice Clarence Thomas of the Supreme Court and for Judge Michael Luttig of the United States Court of Appeal for the Fourth Circuit. He practiced law at the law firm of Kirkland & Ellis. He got his JD from the Chicago Law School. What we'll be discussing today will be the format will not be the normal presentation of each subject, but we'll have a sort of a roundtable discussion on four subjects. The four subjects will be, first of all, immigration, the issue of sanctuary cities, and the issue of the federal cutback on grants because of their status as sanctuary cities. And we'll also be talking about to what extent can local government, state government, and municipal government aid and assist, or some people might say aid and abet the federal government in its immigration policies. The next subject will be a subject which is very interesting to me, and which I'll say very little about because we have a lot of cases under submission in the Ninth Circuit on them, as you can imagine, which is the issue of state marijuana legislation. There are some states that have marijuana as recreational, other states that have it as medicinal, a lot of them in the Ninth Circuit. And the situation we have is that there is a appropriations rider which prevents the federal government from spending any money to prosecute actions that are legal within the states. So we'll be talking about that. The next subject we'll talk about will be gun laws. Where are we now with the Second Amendment? The question brings up the question of the Peruta case in the Ninth Circuit, which was denied certiorari by the United States by the United States Supreme Court, and the question of when can a person carry a gun or get a permit to carry a gun. And lastly, if we have time, we'll go into some cases involving establishment of religion and free exercise, and mainly the issue of when prayers can be said at legislative or semi-legislative hearings. So with that, we'll start off with Professor Eastman talking about immigration sanctuary cities and all that involves.
And I think we're just going to stay here, right? Because we're doing the... So but before I get into the substance of this, I have to tell a little story about Judge Bea. On one of the immigration cases out of Arizona, and he was named to the 3-judge panel. Now, I'm on a constitutional law professor's listserv, and it may surprise you to learn that there aren't a whole lot of conservatives on that listserv. So few of us, in fact, that they tend to forget that we're there at all. And so this listserv lit up with excitement over the fact that this judge, apparently that they didn't know very well, Carlos Bea, had been named to the panel to oversee the Arizona immigration litigation. Because he lives in San Francisco and he's got a Hispanic surname, ergo he must have been great for their position. And it was wonderful to see that miscalculation on their part.
As usual, I dissented.
Yeah, that's right. So we've got, as you know, a lot of litigation around the country in various aspects dealing with sanctuary city law. Challenges by the Department of Justice to California for having its sanctuary state laws at all. A lot of other jurisdictions that sued the federal government after the Department of Justice started putting conditions on federal grants to at least provide us information about when you're releasing illegal immigrants from your jails so that we can go detain them and put them into deportation proceedings. And one of the more interesting aspects of all this litigation is the shoe on the other foot component of it. So, I mean, I've been fighting for a long time for such things as non-delegation doctrine and states' rights, and I find now all of my leftist colleagues in the legal academy and in the public interest world are big defenders of states' rights and non-delegation doctrine. If I could just hold them to that position now, once the shoes change the other direction, we would have made some great headway here. I suspect that's not going to happen, though. So let's kind of dig into some of these issues. One of the things everybody agrees on is that the federal government can't commandeer state and local officials to do the enforcement of federal law. And so if that's all that was at stake, this would be a case easily resolved by the Supreme Court's Anti-Commandeering Doctrine that dates back to a case that was decided the year I was clerking at the Supreme Court back in 1997, Prince versus United States. Prince versus Texas, I forget the whole rest of the name. The Prince case. But we also all agree that doesn't apply when the federal government has made an unambiguous condition on federal spending. if I'm going to give you a grant to help with your law enforcement, and I make as a condition on that grant that you help the federal government with their law enforcement in return, under the doctrine on conditional spending, as long as the condition is unambiguous, it's related to the spending program, and it's in furtherance of the general welfare, and the amount of money at stake is not so large as to be coercive, that's going to pass. And a straight-out condition by federal spending, if it were to be made by Congress, of that sort, would easily pass that test. I mean, heck, the test was created in a case called South Dakota versus Dole, where they said, set your drinking age at 21 or you lose highway funds, and the court held that was close enough related. If I'm giving you local law enforcement funds to support local law enforcement, and I tell your law enforcement they have to notify our law enforcement before they release somebody from jail, I think that's going to pass the relatedness test. At least when it gets to the Supreme Court. It hasn't done so in some of the lower court decisions, not a surprise. Many of those lower court decisions are in your circuit, Judge. Now, where it gets a little dicey is Congress has not passed a spending condition on these federal grants. They have passed the law that delegates to the Attorney General the authority to impose conditions. So we've got a new little constitutional overlay on this. First, is the new condition unambiguous? And it clearly is. They've made very clear what it is. When you apply for the grant, you know what it is. But does it violate the non-delegation doctrine? Does that condition have to be imposed by Congress rather than by the executive under a delegated authority under the statute? That's never been resolved because we've never had this issue come up before. I'm of the view that this would fit currently non-delegation doctrine, and probably even a non-delegation doctrine revived with more teeth in it, because Congress was fairly clear in its delegation of authority to the Attorney General. And the best case on this so far that I've seen, a guy that really rolled up his sleeves to figure out this, was Judge Lineberger's opinion in Chicago versus Sessions, when these statutes are all over the place. I mean, it's a patchwork quilt, and they've been renumbered and recodified a number of times, and so what used to be subsections are now in different sections, and when the delegated authority says the Attorney General can impose grants, compose conditions on any grants in this subsection, you really got to put the Chinese puzzle together to figure out which of the grants are covered by the ability to impose conditions. And he goes through that and parses through it and says the burn grants are not within that delegation of authority to add conditions. But the implication of his ruling is almost all of the other grants that the Department of Justice doles out are within that delegation of authority. And if that's true, and we look at the old South Dakota versus Dole line and say Congress can delegate that conditional grant-making power to the Attorney General, and then we've got the question, was it ambiguous, is it related, and it clearly is. And so when this case eventually gets to the Supreme Court, I think we're going to see whether that bridge between an unambiguous condition by Congress and an unambiguous condition by Attorney General under delegated power by Congress is still constitutionally permissible. We don't have an answer to that yet, but I think it's an extremely interesting question, and I tend to think that the Attorney General ought to win that case. As long as the delegation of power to him confines the discretion that the Attorney General has and where he's going to impose conditions and the nature of the conditions and what have you, then certainly under current non-delegation doctrine, which is there ain't much left to it at all, but even under a revived non-delegation doctrine, I think that's something that might be upheld. Yeah.
Okay. Deep?
Right.
You're next up.
Thank you, Judge Bea. And thank you to the Federalist Society for having me here. This is very rare, maybe the first time I've been at a Federalist Society event. I thought I'd throw myself right into the lion's den and see what happened.
Well, could well be the last time.
Could be I suspect that's true. I have Amnesty International on my speed dial. Okay, so let me start by, I think there's probably substantial grounds of agreement here thinking through the anti-commandeering doctrine in immigration law and how it prevents the conscription of state and local law officers into federal immigration enforcement. I also agree that if Congress wanted to, and did so with enough specificity, they probably could tie certain grants, at least a limited number of grants, on the condition that states and localities participate in at least some forms of immigration enforcement. In fact, over the last decade, if you look, there have been several bills introduced in Congress by various Congress people, including several from California, which attempted to leverage federal funding on cities and states complying or cooperating with federal immigration enforcement. Very few, I'm not sure any of them made it out of committee. Certainly none of them came up for votes. I think where we likely disagree is that, if you think about the litigation that is currently happening, yes, there are some cases in the Ninth Circuit, the counties of San Francisco and Santa Clara against the Trump administration, but there are 3 other cases, one in New York, one in Philadelphia, the Chicago case that Professor Eastman mentioned, all not in California. And they've all come to similar conclusions with regards to things like the president, on his own authority, in an executive order, can't simply decide that federal funds could be conditioned on states and localities participating in immigration enforcement. Harder question as to whether the Attorney General can then use his authority, or his or her authority, to condition funds like the Byrne or JAG grants, law enforcement type funds. And here I think the hard question is one of whether Congress has authorized the Attorney General to do so. Thus far, courts have found that there isn't enough specific statutory authorization for the Attorney General to make those conditions. The agencies do routinely make conditions on grants, or at least some do. The Department of Education does, but I would argue pursuant to a more specific grant of authorization by Congress. But really, I guess my main point is I'm not sure it matters that much in terms of the practicality of changing the behavior of states and localities that don't want to participate in immigration enforcement. And here's why. The only real federal law that's an anti-sanctuary provision is Title 8, or 8 U.S.C. 1373. Those of you who are not familiar, it's a prohibition on a prohibition. It's a federal law that prohibits states and localities from prohibiting their officers from voluntary communication with federal authorities on immigration and citizenship information. When you look at most sanctuary policies across the country, right, and sanctuary is obviously a very vague term, there's no single definition of it, but when you look across the country, very few jurisdictions actually violate, certainly not purposefully and maybe inadvertently, but very few jurisdictions actually violate 1373, especially after a Second Circuit case from 1996 called New York versus United States. Most have to do with, most sanctuary policies actually go to detainer requests, that is, the request by the federal government that a local authority hold somebody, detain them for ICE to pick up. That can't be commanded by the federal government. It would be a very clear anti-commandeering issue. And otherwise have to do with the investigative authority of their own personnel. That is, when you go about doing your local policing, don't ask about immigration matters. That is not covered by 1373. So, at the end of the day, even if 1373 is made a condition of Byrne and JAG grants, it's unlikely, in my view, that it's actually going to make a significant difference. And the final thing I'll say on this topic is that 1373 itself is under some constitutional doubt. If you look at the Philadelphia case and the Chicago case, both were reconsidered by the district court judges after the Supreme Court issued its Murphy versus NCAA ruling on the professional and amateur sports gambling federal law. In reconsidering their opinions after that case, they both decided that there was significant constitutional doubt with 1373 itself, a federal law that purports to take certain matters out of the control of state and local police departments or city councils or county supervisors. And I think that's an issue that will percolate up through the courts.
Okay. John?
Thanks. Well, I'm still stunned by what I've heard, that we have allowed someone on the federal bench who is subject to a warrant of deportation. And I'm sure if Senator Harris had been Attorney General, Kamala Harris would have made an exception in the sanctuary city policy and had city and state officials cooperate with the federal government to eject you from the territory. But Mayor says, thank you very much. It's really great to be at the Reagan Library in this conference. I think I've been going so long to this that I remember when we would just have the whole convention in the little cafe upstairs. So it's great, wonderful that the society is sold out and everybody is here. I also love to see that everyone here has the same challenge I do as a conservative, which is trying to figure out what one wears on a Saturday. Because as a conservative, during a business function, of course, I'd want to wear a tie, but I don't know what to do on a Saturday. I know liberals have no problem with this because they believe in no standards at all, and when it comes to just generally, but also with dress. So I spent more hours trying to figure out what to wear than Justice Scalia spent writing Prince and New York versus United States. So just a few observations. I want to join John in pointing out the liberal scholars' hypocrisy on immigration, because when they were defending President Obama's decisions not to enforce immigration laws in the DACA and DAPA programs, I save you all the trouble of having to read the thousands of law review pages that exalted the power of the executive branch to wield together so many different contradictory positions on statutory provisions on immigration law, which make no sense. And Congress is telling the executive to do one thing and then another thing on immigration law. Only the president could centralize and unify immigration law into a single coherent policy. You don't hear that said for the last 2 years. This was written over and over again by the most prominent scholars and the most leading law reviews. So I think there's some hypocrisy going on here. You just don't hear any defense of this idea. If you believed in that idea, then you might actually have more sympathy for what the Trump administration is trying to do. A second point is, I do agree with both of their descriptions of what formal constitutional doctrine says in the anti-commandeering cases, but there are two, I think, still questions kind of left open. One, Deep just mentioned, information sharing. So I think the thing that the federal government would probably prefer more than actual cooperation and catching people or anything is just information on when felons are being released from state and local prisons and jails so that ICE can show up and enforce the detainer at the very moment. And for those of you who are in law school more recently enough to have read Prince in New York, you know that this question of information sharing is left open. Could the federal government just force states not to actually do anything more than just provide information? There's some odd cases, this Conlin case out of South Carolina, where the Supreme Court actually upheld the federal government's right to force departments of motor vehicles to cooperate in terms of information with the federal government that opened the door to this. So there might be more actual space for, I wouldn't call it commandeering, but some federal commands to be binding on state governments in the immigration context. We just don't know. The Supreme Court has never explained or filled out this information area. And then the second thing that's, I think, difference is, does immigration and foreign affairs make a difference? So New York versus United States, very fascinating case about where to store low-level radioactive waste in the country, right? This is where the United States government, the Congress, tried to force New York State to take title to radioactive waste. Not the biggest, most compelling issue on the docket of the nation at the time. The Prince case was about temporary law about who was going to run background checks for gun purchases. Right? Again, not the most compelling issue, not the highest federal interest. And I think the question that was raised in the case, I thought that was interesting, that the dissenters actually raised both times, well, what if it were a war or national emergency or foreign affairs crisis? Do we really think that the federal government couldn't get state officials to help operate the draft or to help run civil defense and so on and so forth? Think about our early military was primarily composed of state militia officers and the state militaries in the days when there really was no standing army. We used to have, at least in national security, foreign affairs area, much more cooperation between the federal and state governments as institutions. And would the current court think of immigration as primarily domestic law enforcement, like low-level radioactive waste, like background checks for handgun purchases, or would they think about it more like national emergency, national security, foreign affairs? I hear there's this thing called a wall people have been, but I think we're told now we have to call it a barrier. So this is essentially the same question that's being raised about, can you declare a national emergency and build a wall? Because if you think it's just immigration law is just domestic law enforcement, well, then President declaring a national emergency doesn't access powers to build the wall. But if you think immigration is actually more like foreign affairs and national security, then there are all of these statutes about declaring national emergencies and the powers the president has to reallocate military construction funds. So I think that's still left open by the commandeering cases too that haven't been resolved yet and would be important. A second point, I do agree with both that this question of conditions on spending is really the nub of it, and that the Supreme Court has just the Dole case, which John described, and then his other favorite case, Sebelius versus NFIB, the case that upheld the Obamacare case, was actually the only time the Supreme Court has struck down spending conditions. And because the cutoff in Medicaid and Medicare funds threatened by the Obama administration for not cooperating with Obamacare was thought to be too much of the budget. And so I agree that this is where we are in constitutional law doctrine. I'm not sure that it's a non-delegation issue. I think it's really a question of like administrative law. When Congress gives the president power to distribute grants and it lists conditions, should we consider those to be exclusive conditions, or can the executive branch add on more conditions as a course of running a rational administrative policy? Under the Chevron doctrine, would that not get deference from the courts if the executive branch is going to say, not only does Congress want us to allocate the funds in these three ways, but we think in terms of good governance, there should be another factor? I think I wouldn't think of that really as a delegation doctrine question so much as a question of just, are the courts going to defer to what the executive branch thinks is rational? And then one last thing. I think in terms of politics, and the way we want there to be a diversity of policies in the country, isn't it a good thing that there are sanctuary cities? Shouldn't San Francisco be able to set its own course, and then shouldn't they suffer for it? As someone who lives in San Francisco, right? If my city wants to have more people who could be deported who are felons running around on the streets, where they'll run into into homeless people when they're trying to, my city's become totally ungoverned. But if you wanted to have that, and the people of the city of San Francisco want to have that policy, and they don't want to have, suffer the cost of $5 million in Justice Department grants, they should, I think, reap the consequences of those decisions. They have a policy. Our voters keep returning to office the people who support this. And if the cost is a few $1 million, I'm sure the voters in San Francisco will be happy to lose the $5 million in grants as the cost of that policy.
Thank you for the suggestion, John, that we can be more virtuous in San Francisco and poorer. I want to ask before we go to the next subject, maybe you've got a couple of comments, and then we'll go on to the fascinating subject of medical marijuana.
Yeah, just one point of slight disagreement with John, why I think this is mainly a non-delegation issue rather than a Chevron deference doctrine issue. Title 34, Section 10102, specifically authorizes the Assistant Attorney General in charge of justice grant programs, quote, to place special conditions on all grants under this chapter and to determine priority purposes for formula grants. So I think that's pretty clear that there's been a delegation of authority to add new conditions to the grants. The only issue in the Chicago case was, is the Byrne grant one of them covered by that chapter? But the strong implication from the holding by the district court in that case, and it's pending in the Seventh Circuit on appeal right now, all of these things are now hitting appeals. We've got arguments in one of them later this month. We've got another argument in the Seventh Circuit one, I think, in March. So we're going to get a lot of resolution on this in the coming issue. But I think that statutory delegation of power is where the real nub of this. Anybody that's really rolling up their sleeves and figuring out what the law actually says, I think you know, that kind of is the crux of it right there.
Deep? Got
Sure. I think I'm being asked to stand up for all apparently liberal law professors here. No, I will say, look, I don't think, just as a broad response, my view is that federalism is not all or nothing, and one can inflect their idea of federalism and structural allocations of power with other ideas that are in the Constitution. So you can normatively inflect it with other aspects of the Constitution, which I think are quite important as well, due process rights, individual liberty rights, all those sorts of things. But getting to a more specific response, you know, I agree to John to this extent. That is to say that if one thinks of immigration really as about national security, only about national security or foreign affairs, that might lead to a different set of conclusions as to the type of constitutional doctrines that should apply in the area versus other types of mainstream doctrines or ideas of construction. My own view is that it's not proper to see immigration only as a foreign affairs and national security issue, and therefore there very well might be domestic mainstream constitutional standards that should apply. Certainly there are aspects of immigration that might touch more specifically on the foreign affairs concern. And I do think that just like John was saying, that San Francisco or other cities should be able to experiment and make their own decisions about sanctuary policies, at least as to the extent they are not, they're exercising their right not to be commandeered or overly coerced with spending. You know, I think the flip side of that is that the federal government has to internalize its costs of enforcement, that if it writes immigration rules that make, you know, whatever it is, 12 million people, 11 million people unlawfully present in the country, and wants to get the help of local law enforcement officers in removing those persons, then the federal government has to also internalize those costs, either by paying for it or by deciding that those rules are not fit for our immigration system.
All right, shall we move on to the fascinating subject of medical marijuana and recreational marijuana, and how federal statutes may or may not conflict with local rules.
You want me to start? Okay.
Yeah.
So the appropriation rider that Judge Bea referred to earlier says that there shall be no federal enforcement of our drug laws in states that have removed the illegality of possession or sale as a matter of state law. I phrase that very carefully because you often hear people say that California legalized medical marijuana and Colorado legalized recreational marijuana. They did not. It remains a Schedule I drug and it's illegal under federal law. One of some of the collateral issues that have arisen out of these state law or state initiative efforts have been, when I make a profit in selling this stuff in violation of federal law, where do I deposit my funds? Because if I deposit them in a U.S. bank, the bank's assets can be seized by the federal government. So you got all these collateral issues. The appropriation rider starts to try and address those issues by not letting the federal government enforce its drug laws in Colorado, where Colorado is legalized. But that's not the only enforcement authority of our drug laws. One of the predicate acts for the racketeering statutes are the violations of the drug laws. Anybody that is party to the drug law transactions, including the cities that license them, are parties to the RICO enterprise. And RICO doesn't only get prosecuted by the federal government. There's a thing called civil RICO. Anybody that is injured by the federally illegal conduct can bring a civil RICO action with treble damages. So the easy actions would be somebody driving under the influence of one of these illegal drugs causes a car accident. The injured parties in the car accident have a civil RICO with treble damages and attorney's fees. Or my favorite theory is there's pretty good evidence that when I put drug dispensaries in a neighborhood, property values decline. So a class action on behalf of all property owners for the decline in their value, that treble damages award starts getting pretty large pretty quickly. I'm waiting for the plaintiff's bar to take up these things, right? So the appropriations rider on the federal government saying the federal government can't enforce it in these jurisdictions doesn't solve the problem of people are still engaging in illegal conduct, and there is a mechanism by which they can be held liable for it. Now, let me back up one step. I think the Supreme Court got it wrong in Raich versus Gonzalez when he said this exercise of Congress's power to regulate commerce among the states extends to homegrown, non-commercial medical marijuana use in California. I don't think that's a valid exercise of the Commerce Clause. But I'm not willing on that particular issue to think that the Supreme Court was so clearly wrong as to go to war over it. And that means that decision that this is a valid exercise of federal power is the law of the land. And I think, you know, these jurisdictions that are ignoring it are really launching a kind of new nullification crisis about the authority of federal law in their own jurisdictions. And I think that's a fairly troubling thing that we ought to be confronting.
Deep?
Sure. You know, I actually do think that Professor Eastman's right, that there is a real concern here with marijuana regulation. Because the preemption issue here is quite tricky, especially when one combines the preemption issue with what the remedy is if and when a court were to take that case. So here's the thing, right? When you have anti-commandeering doctrine like we were talking about, it's true, and especially after the Murphy case, the federal government can't force states to make marijuana illegal. They can't force them to criminalize it. So I don't think that's the concern. The concern, though, with the preemption case is what happens when a state then creates a licensing scheme, a regulatory scheme that people can apply for, get licenses, and then have dispensaries within the state or local places to sell it that are within that scheme. The appropriations rider, by the way, only deals with medical marijuana, right? So it actually doesn't touch recreational marijuana. The other thing that's interesting, I would say, about the rider is that I believe the last version of it listed 47 states in which the Department of Justice could not use funds to stop the implementation of medical marijuana schemes. That's a lot of states. There are currently 8 states that allow recreational marijuana, and I think 37 that, at least more than half that allow either medical or recreational. So it's a lot of states, so certainly one might think of it in terms of this idea of nullification. But getting back to the preemption and remedy problem, so you had a suit by Oklahoma and Nebraska against Colorado trying to invoke the original jurisdiction of the Supreme Court, which the Supreme Court denied. And the suit went nowhere after that. But in that suit, their main claim was a preemption claim against Colorado. And I think that there's sort of 2 aspects of that, or 2 concerns with that suit, right? The first is, it very well might be that a court could find that the state licensing and regulating and giving the ability of medical marijuana dispensaries to operate is a preemption problem given the Controlled Substance Act and marijuana being listed along with heroin as a Schedule I substance, which seems crazy. But be that as it may, think about a federal court or the Supreme Court being faced with that. What's the option? The only option underneath the preemption suit would be to strike down Colorado's regulatory scheme. They can't force Colorado to recriminalize it. So then the response, I think, it would be an odd thing for Nebraska and Oklahoma to then be asking, because their claim is that we're being injured by marijuana coming across state lines into our state. Is it better when it's not regulated in Colorado? Is it better when it's regulated in Colorado? Probably the latter. Several states, by the way, submitted amicus briefs before it was rejected by the Supreme Court, arguing, look, we don't have a problem with other states not criminalizing it. We'll just keep our state troopers on the border to stop that marijuana from coming in. So I think that's...
With the border wall, I think, right?
Right, exactly. So anyway, I think that's a serious concern as to what exactly the response is to a preemption suit by one state against the other. And the other thing I'll just quickly mention is that the other odd thing, at least about that suit by Oklahoma and Nebraska against Colorado, is that the defendant in the case is Colorado, right? So I'm not sure how far that goes to stopping any scheme of marijuana regulation, because you're not including the very important dispensaries, growers, manufacturers, distributors of marijuana in those suits. Usually when you've had states make suits against other states on parens patriae standing in, for example, the pollution context, the defendant is the polluter, the company that is creating the pollution. And so it's just a very odd suit, and I think it's quite messy to figure out what to do in these situations.
John?
Thanks. So this is, this issue of the legalization of marijuana is very interesting to me as a teacher, because I'm sure, well, we've all gone to law school, I suppose. Although maybe Judge Bea was one of the people who got on the federal judiciary also by not going to law school as well. I have no idea. Well, you went to Stanford, so it's close.
Says the guy from Berkeley.
Exactly. Because as a teacher, right, we know the hardest thing to do is to get students to read closely a statutory code, right? They don't like doing that. For curiously, however, when it comes to medical marijuana legislation, I have found my students to be very close readers of the statutory code. I'm sure they would know exactly how many states have legalized marijuana and could tell you exactly which ones they are. Without regard to my former students who were in class, none of you actually displayed this kind of excellence at statutory construction. So just a few points. So I agree very much with what the last two speakers said. So I wanted to throw out the question, what if you were the faithful originalist president or the faithful originalist attorney general, and you thought Gonzalez versus Reich were wrong, right? You thought that the Commerce Clause does not extend to federal criminalization of individual transactions in any substance wholly within state borders. So that in the Gonzalez, I know the Gonzalez versus Reich case very well because I looked up the facts, and the facts actually occurred two blocks from my office. Because I live and teach in Berkeley, so where are you going to find people who grow the marijuana in their backyard and transfer it without sale? They just give it out for free? Berkeley, California. Those were the facts of the case. It wasn't even a commercial transaction. It was a gift of marijuana. Yeah. So suppose you're an originalist attorney general, an originalist president, and you think, as John said he does, and as I do, the Commerce Clause doesn't reach into a purely intrastate transaction with nothing crossing state borders, then wouldn't actually the right thing to do as Attorney General or President is to order with the withdrawal of all federal law enforcement from those states that have legalized the sale of marijuana, right? Right, the Supreme Court can say what it wants about Gonzalez versus Reich and this reach of the drug enforcement laws. The President has the right to set law enforcement priorities and take care that the laws are faithfully executed. He believes, or she believes, as a matter of their own good faith construction of the Constitution, that federal law, in many cases, when it's applied, is unconstitutional. So why can't the President, so why doesn't President Trump not only, right, wait for this rider, but actually implement it before the rider is passed? And I think the virtues of federalism are advanced here because our society is divided about whether marijuana should be legalized, what the consequences are. Isn't this actually one of those laboratory democracy moments where we would like to see states have a variety of policies? And if California descends into a vortex of, oh yeah, it is like Berkeley, the vortex of pot smoking, people, marijuana, Doritos production and consumption goes way up in California, but we have a lot of people driving slowly on the roads and don't know when to turn right or left. Let us suffer the fate of, the fate to which we are due in California. And if some states want to ban marijuana and fast food consumption goes down in their states and people drive correctly more often there in those states, then we can see the consequences and make a choice. Why isn't, when it comes to the question of marijuana, why isn't that kind of diversity of policy in the country something that an originalist or conservative president, attorney general should favor? And so this might be a good use of prosecutorial discretion even before you got to, Congress cutting off funds and say, I would say President or Attorney General Barr could, I think, legitimately say, I'm going to withdraw the DEA, and I'm going to withdraw federal law enforcement on marijuana from all of those states.
So the interesting aspect of that is, what if the president thinks Gonzalez versus Race was well decided, that is within the reach of the Federal Commerce Clause, but just as a matter of policy disagrees with Congress's policy adjustment, so wholesale suspends enforcement of the law in that state? I think that's the situation we had when President Obama originally decided not to enforce the drug laws in these states. He didn't question the constitutionality of the law, he just didn't like it. And so then you've got the same type of question that we had with the suspension of the immigration laws in DACA and DAPA. I disagree with the policy. No challenge to the constitutionality of those laws, but I have a different policy, and so I'm going to pretend to be exercising prosecutorial discretion on a case-by-case basis, because that's what the law requires me to do, but what I'm really doing is wholesale suspending the law. And I think that exceeds the authority of the president. The question, and the court has suggested there is a line there, but they've never decided what the line is, because as you really look into it, it's a darn hard line to draw. How much enforcement is suspension versus how little is prosecutorial discretion? And ultimately, I think if the court is forced to actually address that issue, they're going to say, this is a non-justiciable question. But it's a different question than the one when the president, exercising his own oath of office duties to take care that the laws be faithfully executed, which means execute constitutional laws and maybe not execute unconstitutional laws. Just by disagreement on policy, I think that may well go beyond that executive discretion.
Deep?
Yeah, so maybe it's just sort of a question for John, really. I'm sort of curious. I agree with you that the president might, in good faith, say, I think the law or the policy itself is unconstitutional, and therefore exercising my own obligations to interpret the law, I can't, in good faith, prosecute it in that way. That is certainly not the tack, right? If you think about the Cole memo, that's the memo that was issued during the Obama administration, at the beginning of legalization, where the Attorney General said we're not going to prosecute in certain ways, and states that make sure that they're in strict compliance, at least with state law, unless it's a federal priority and all that, we're not going to go after them. So it's not a claim about the unconstitutionality about the Controlled Substance Act, and there's good reason why most presidents, I don't think, would say that they think the Controlled Substance Act is unconstitutional, even in its furthest reaches. Why? Because I think it's probably institutionally, there's incentives to make sure that the enforcement apparatus can extend as far as possible, or for other reasons. I do think it's possible for example, an administration to make a much more in-depth argument about resource allocation and where they want to spend their priorities. That's what enforcement agencies do. But without that, I'm just curious, isn't there a take-care problem in the uneven enforcement?
Yeah, this is why I threw it out, because the DAPA-DACA case is too easy, right? Because President Obama said in these classes of cases, we're just going to make enforcement zero. So you didn't have this harder question about what if it's something between zero and sort of maximal enforcement, which no federal statute has, and then what are we going to try to place limits on how the president decides to allocate law enforcement resources? Could they do it? So we're accustomed to the president and the Attorney General saying, I'm going to allocate law enforcement resources based on certain high-profile cases and amount of marijuana, and did it come from abroad? But suppose presidents did it on totally different factors, like geographic. Right? Suppose I want to enforce the drug laws more vigorously in certain states, but not others. Right? That would be interesting. There's no cases like that we've seen come in the Supreme Court. I tend to think the president could do that, because he is taking care the laws are faithfully executed. He just has a good faith belief in the best way to execute the law. And maybe he thinks the best way to execute, or she thinks the best way to execute the law is by focusing in those states where it's already illegal. And so I think it's interesting, the DAPA-DACA thing also, because what President Obama didn't claim, and I've always thought it would be more interesting and difficult for judicial review, was if he hadn't said, I'm setting the DAPA-DACA levels of enforcement at such tiny amounts, but what if he'd also done it state by state, or had defined the categories a little more loosely, so there were, let me say, 10 or 20% more cases being brought, but not the 100% of before. I think that would have been much harder for federal courts to intervene and review and try to strike down.
I want to just add a note of optimism to Professor Yu, he said that his students are much more interested in statutory interpretation now because they want to interpret the state statutes to prevent prosecutions.
Oh, no, I meant they just wanted to figure out how to smoke more pot. let's not make it.
Well, the good news for your students is that we've had a recent case in the Ninth Circuit where a state said that you could only have a certain amount of usable marijuana in your possession if you were a medical marijuana provider. And the government said, well, this dried marijuana qualifies. So the statutory interpretation was, is dried marijuana usable, or do you have to do something more to be usable?
I would have to defer to your expertise on that.
All right, we'll turn the page from the drug component.
Wait a minute, John, does that mean just because you're at Berkeley, you don't have to use it, you just breathe it? Is that the like going to a Grateful Dead concert?
Secondhand smoke in America.
The next subject, the clash between federal and local control, is the question of Second Amendment and gun laws. So, John, why don't you lead off?
Sure, and very timely because just this week the Supreme Court granted cert in the first gun control case in a decade or so. You know, there have been a lot of lower court cases that have been percolating up and that surprisingly got cert denials because there are a couple of significant issues still to be resolved by the court. You all know Heller. Heller interpreted the Second Amendment as protecting a personal right to keep and bear arms. It rejected rational basis review in the course of that decision, but it didn't tell us what level of heightened scrutiny we're going to apply. The second thing it didn't tell us is because Heller involved the District of Columbia, a federal territory, whether we were going to incorporate that doctrine and apply it to the states. That comes in City of Chicago versus McDonald. And that case said, yes, it's incorporated. It's an interesting Marx question on what grounds. 4 justices said on substantive due process grounds, including the great anti-substantive due process Justice Antonin Scalia. 1 justice, the narrowest decision, said it was invalidated on privileges and immunities grounds. We ought to get rid of Slaughterhouse and revive that actual constitutional text. But 5 justices said one or the other of those clauses is sufficient to apply this to the states. What it left open was the level of scrutiny. If it's a Second Amendment right, personal right to keep and bear arms, like the First Amendment personal right to free speech or free religion, ought it not get strict scrutiny like we do with other fundamental rights? Or is this a unique fundamental right that's more like intermediate scrutiny? And we're going to look at all of these restrictions more like time, place, and manner restrictions on the exercise of your free speech rights. Those questions remain unanswered by the court. Lots of ink spilled in the law reviews trying to leave out the various passages in those 2 cases on what they really set a standard already. But a lot of the cases coming up that have addressed this are just floundering on what the standard is, and they go all sorts of places. So the new cert grant on Tuesday, I think, is going to be very significant for addressing some of those questions. Justice Scalia in Heller says, you know, there are a lot of regulations that are still going to be valid. I can prohibit you from carrying an Uzi into a courthouse or into a school. But he doesn't really offer any rationale on why that would be the case. And if you apply it in the First Amendment context, could I stop you from wearing an armband into the courthouse or the school? And the answer to that has clearly been no. And so there's something going on where they're recognizing a difference in the nature of the right protected by the Second Amendment, but they haven't quite figured out what that difference is and what it means in consequence. So the New York statute that just got cert granted on was you can own guns in New York because McDonald's says you can, but you can't carry it out of the city limits. If you're going to go practice with your gun, you can only do it in New York City. Now, I would have thought New York City would want the opposite rule. But I guess I can, I don't know, do I shoot pigeons, clay pigeons in New York, or real pigeons off of the Empire State Building? I don't quite know what their thinking was behind this statute. But the severe restrictions that prevent people from taking their hunting rifle to a place where you can actually hunt outside of New York City, or their pistol to a gun range outside of the Bureau of Manhattan, the law said you can't. It was upheld, and that's on which the court granted cert. And so I think in the way of deciding that case, we're going to learn a lot more about the level of scrutiny and what kind of restrictions are going to be permissible and what not.
Deep?
Sure. Yeah, so just thinking about that New York law, as John said, my guess is that it's going to be a fairly easy decision for a court to strike it down. And then the question really is to what extent that court decides that Heller is more than about the home, and to what extent the Second Amendment exists outside of that, or can be protected outside of that, which then might bring into question the Peruta case and the idea of discretionary issuance of concealed carry permits. But one thing I'm sort of interested in is this notion that the type of scrutiny that lower courts have used in the wake of Heller is somehow relegating Second Amendment rights to, as I think Justice Thomas who said it's a second-class right? Maybe, but I will say this: it's not quite. I'm not certain that all things that we consider fundamental in the Constitution necessarily get strict scrutiny. If you think about even within the First Amendment context, yes, there are many parts of the First Amendment that get strict scrutiny, but there are other aspects of the First Amendment that look a lot more like an intermediate type of scrutiny. Same with Equal Protection Clause, right? There are certain classifications that get strict scrutiny, certain ones that don't. The Fourth Amendment, I don't think anybody would argue, is not a fundamental right, the idea of being free from unreasonable searches and seizures. The Fourth Amendment certainly does not get strict scrutiny, and I would say the similar things about the Fifth Amendment, the Sixth Amendment, Seventh and Eighth Amendments as well. So, yes, it's not strict scrutiny that's being used in the wake of Heller, but it's not clear that that alone makes the interpretation of lower courts of Second Amendment rights and state and local regulations a constitutional problem. At the end of the day, the United States still has the most permissive gun laws of any industrialized Western nation. There are 400 million guns in private hands. I'm not sure I would necessarily characterize what's happening as a significant restriction in the ability of people to get firearms, even with the state and local laws that are there. And certainly there are some, like the New York City ordinance, that are outliers that are probably fairly easy to strike down.
John?
So this is different than the first two cases of marijuana and immigration, because there is no constitutional individual right at issue there like there is here. So there is some level of national uniformity that is required. And then the question is just on top of that, how much diversity of policy should we allow? So I do think the Supreme Court has been derelict. Whether you agree that the court should be more vigorous in its scrutiny or more generous to states and localities scrutiny, the problem is that the Supreme Court identified a right more than 10 years ago and never granted another case. And I think the court has been derelict in its job here. You look at other areas of rights, whether you agree with the right the court found or it didn't. It usually then proceeds to set out how far that right goes, take some exemplary cases about the standards of scrutiny and what factual situations should apply for upholding or not, and never did that with the Second Amendment. So it has it's not even delegated, it's just sort of thrown up its hands and let the lower courts fill it out. Where I might add, most of the restrictions on firearms by state and localities have been upheld by most of the federal courts. There are very few that actually have been struck down. The second point is I would still think the system should allow more diversity of, even if you were to take a strong view in the New York City case or on the original McDonald case, how far the right should go. And maybe the way to do that is different. I think maybe a different way to think of the test is, I think the whole structure of strict scrutiny, intermediate scrutiny, rational basis is just a made-up thing by the Supreme Court anyway. Right? I mean, it's just like mostly to... Well, let's go down all the other stuff they made up too, and that's like applause, louder or less loud for the ones we disagree with. I mean, they make up a lot of stuff, and the standards of scrutiny are of course, just an artificial, creation of the courts.
Oh, we don't have three. We've got rational basis with bite, intermediate scrutiny, super intermediate scrutiny, strict scrutiny.
You've been teaching recently. So why not have a different approach, which I think, again, would be more consistent with sort of my view maybe of having a good faith originalist executive branch would be, why not actually just look at the kinds of restrictions on firearms that existed at the time of the ratification of the Bill of Rights, and to see what states and localities were allowed to do and were not allowed to do, and use that to draw our views on what the court should allow. Look, I bet you'll see more diversity of different kinds of regulations permitted than under a strict or intermediate scrutiny approach. But at the same time, I think you would actually have real clarity about what the government can and can't do, rather than just behind the veil of strict scrutiny and intermediate scrutiny, really just allowing the court to make policy decisions about what things seem like a good idea or not to the court.
So here's one of the difficulties. First, you got to look at the kind of the practice in 1868 on how it's going to apply to state and local jurisdictions, which is
I agree.
And but the second thing is, and this is where the courts are going to have a great deal of difficulty, and that is a regulation that might have been in place then, but is now used for the purpose of preventing you from exercising the core of the right itself. So California's gotten pretty creative in figuring out ways to do this. So I know we can't prohibit you from owning a gun in your home. That's how they're interpreting Heller. It's limited to the home. But I can, and I can't, force you to keep it locked up. But I can prevent you from buying ammunition. Right, and so we get the ammunition restriction, or we get an unbelievably costly regulation that every single bullet that you purchase has to be laser engraved. So instead of costing 10 cents a piece, they're $100 a piece. Now that's not a restriction on your right to own the gun, but can you imagine in a comparable First Amendment context such a tax imposition on ink not being a violation of the freedom of the press? So using these kind of regulations as pretext for restricting the right that the Supreme Court has recognized is what we see a lot going on. Now, if I'm a judge, and I'm never going to be one, I'm pretty confident of that, but if I were a judge, how do you grapple with that pretext intent? It's an extremely difficult thing for a court to do, to look at the motive behind the restrictions and see if the motive goes too far. And I suspect the courts are going to have to throw their hands up on that.
Maybe I'll just start by saying, look, I think that one could, even if you go and do a historical analysis, one could come to the conclusion that the Second Amendment has always been interpreted to allow for some regulation, some reasonable regulations of firearms, short of bans or prohibitions on those firearms. I think the pretext problem is not insurmountable. That, at least, is one theory of why courts have the made-up levels of scrutiny, is to suss out the impermissible pretext, and you could see it work. Arguably, you could see it working in a case like the Third Circuit took with regards to New Jersey's firearm, their magazine capacity restriction, in which the government actually had to show some evidence to support why it is that it thought that certain types of regulations were okay and not okay. It couldn't just make the assertion, but had to provide some evidence. Now, there's a dispute in that case as to whether the evidence offered was sufficient or not. There's a dissent that said it wasn't, and but that's going to happen. That's going to happen in any type of case. But I think it was a sufficient judicial model, at least, to address the problem of pretext that you're suggesting.
Shall we pass on to the last subject, which is the establishment of religion and exercise of religion? with respect to
So,
California? And
yeah, so, you know, I think this topic is triggered by the Supreme Court's Masterpiece Cake Shop case, and the very expansive use of state public accommodation laws that is now being deployed to shut down opposing viewpoints on controversial social issues like same-sex marriage or what have you. And Jack Phillips, you know, you all probably know the facts. Jack Phillips was asked to bake a cake specifically celebrating a same-sex marriage in a state that at the time same-sex marriage was still illegal. And so he, in declining to celebrate that marriage, he did the same thing that the state government was doing. He got charged before the Public Accommodations Commission for sexual orientation discrimination. Now, this presented, I think, a particularly unique problem for Justice Kennedy, whose, I think, two most prominent areas of jurisprudence, if you look back over his career, were that he was the swing vote on all of the free exercise of religion and establishment clause cases, sometimes going one way, sometimes going the other. But he considered that a very significant part of his legacy. And then, of course, he was the author of all the major gay rights cases, and he considered that a major part of this legacy. And these two things come into conflict. And when Justice Kennedy asked that question in December of 2017 at the argument in Masterpiece Cake Shop, it seems to me that this commission exhibited an overt hostility toward religion. He had pretty clearly indicated that he hadn't resolved how to reconcile his two lines of jurisprudence, but did find a way to punt the can down the road past his retirement and let somebody else deal with the mess. Now, what's the mess? We have now turned the notion of state-sponsored discrimination, which is prohibited by the 14th Amendment, into allowing the state to require discrimination on the basis of religion in this expansive reach of its public accommodation laws. Anybody that exercises their employment or their business in accord with their religious principles that run afoul of new doctrine is going to be shut down as a result of this expansive interpretation of public accommodation laws. So the state action is causing the anti-religious discrimination in order to prevent a third party, private party, from engaging in what it considers to be discrimination on the basis of sexual orientation. That really seems to me to get things turned upside down on the notion of the state action doctrine underlying the 14th Amendment. And it's that conflict that is increasingly coming to the forefront with these kind of cases. Now, lots of ways out of it. We ought to, you know, curtail this expanse of the public accommodation laws to reach every single activity you do outside of your home or your church or your synagogue. People ought to be able to be free to engage in business what they want unless they were a true public accommodation or common carrier. The limitations on that doctrine when it was established confined it itself. But now you look at the Unruh Act in California, and it's been mimicked in most other states. It's business, service, anything where you're out in public constitutes a public accommodation, and the third-party restrictions caused by the government enforcing this law has really created a new set of problems that I don't think were conceived of. And I think that's the conundrum that Justice Kennedy was in. He didn't know how to resolve it one way or the other, and he punted it down the road. But I think if we're going to continue to be a free people where you can carry your religious views into public and how you want to conduct your business or what have you, that issue is going to have to be confronted.
Deep?
Yeah, I'm happy to cede my time to John. I mean, I'll just say that this is a difficult issue only if you believe that in general norms of, I actually don't see it as as necessarily a hard federalism issue so much as a more general issue of an individual rights claim or religious exercise claim versus any type of broad anti-discrimination provision. And I think there's always you're gonna have that conflict, and it depends on, a balancing of values that I think is quite difficult to do. And, you have the Bob Jones case, an interracial relationships and the question whether there's a religious claim against that. And so we can either try and make distinctions amongst different types of anti-discrimination law, but it's not a problem that's going to go away unless we have some overarching theory of which of these sorts of underlying constitutional norms we think is weightier.
John?
Yeah, I'm going to cede my time back to you. I don't really know what to say either. Initially, I didn't think of this as a federalism problem at all, actually more just like individual rights versus the government. And I don't know whether it would be different, whether it's a state government or the federal government engaging in the kind of activity we saw by Colorado. I do agree, I thought Masterpiece Cake Shop was a really lame opinion. So, right, the state of Colorado is trying to force a baker to bake a cake for a gay marriage, is that right? Putting as a side note, when did conservatives think that baking constituted free speech? I mean, we don't think nude dancing is free speech, but if she were to take the cake and spread it all over herself, would that be free speech? I just thought that was really strange because conservatives used to think conduct and speech were different. Anyway, so the baker has a free speech right apparently to bake or not bake. But for the court to say that the reason the Colorado regulation was struck down was because the intermediate state administrative body spoke in too mean a way to the baker to his face is just, I mean, that's just ridiculous. I mean, it's just not really a holding, it's just a fact, I mean, that was its intention, a fact-bound decision that will have almost no precedential value. So I think the thing I would ask about federalism and religion is, would we be willing to allow on the margins, state differences in attitudes towards religion? I don't think that's something we've really asked ourselves before. We always used to saying the United States, as you said, is unique, as when it comes to guns, is exceptional. The other thing scholars would say who study our differences with other countries is that the other thing that makes us a truly exceptional country is the high level of religiosity in the US compared to any other Western industrialized nation. The United States is just far more religious people, believe in God far more widely in the United States than any of our peer countries. And these are given as explanations as to why the U.S. is an exceptional country. We haven't really thought before, I think, would we be willing to allow a certain diversity of policy and attitudes towards religion by the states? And would we be satisfied with a country where people moved and lived in different parts of the country based on whether they thought it was religious friendly or not to religion? So I don't know if that's true now. I mean, anecdotally, I hear people do choose to live and go to certain schools based on whether that state is friendly or not to religion. That would actually be interesting, I think, from a policy perspective. You know, if you believe in federalism as the laboratories of democracy and also allow diversity of preference to exist, what would we think would happen in the states which more people were moving to because they're more religious? So maybe people think already the South is such a place. People who are more religious live in the South. Would we see different levels of, family formation, children, crime, education? It actually would be something that we would, I think before this, would not really have ever asked before. But I think now, if we are going to allow this kind of diversity of policy and religion that the court, I think, left open after Masterpiece Cake Shop, and that's an uncomfortable thing, but it would actually yield really, I think, interesting policy outcomes.
I'm going to have to cut you all off because there's going to be some time for questioning from the audience. We've got 15 minutes, so anybody wants to ask a question, we have a roving microphone, so hold up your hand down here. I'm going to ask you to hold off till you get the microphone because this is going.
Can we make fun of him until the mic gets there?
On C-SPAN.
Yeah. Oh, I guess not.
Thank you so much. There are so many issues and so many questions, but fundamentally, I'm just getting a sense there is a growing cancer on our whole concept of jurisprudence, and this cancer seems to be executing our fundamental past beliefs of justice and truth and wisdom. And it seems as if there is an eclipse these days on the part of favoring the beliefs of Marx and Muhammad, leaving out, in large part, the teachings and the values and the beliefs of Moses. And since things are so radically changed in the past 10 years, I fear for the future of our children. Do you have any comments you could possibly make on what I say, or is it just outside the realm of now the legal system?
I fear for the fate of your children, too, because they're yours.
No.
No, that's just a joke.
Look, one of the things about eclipses is, because we just had a lunar eclipse the other day, you watch it and then it comes back. And the solar eclipse from a couple of years ago is fascinating. The sun gets completely blocked out for a while, and then it comes back. These things, I've gotten old enough now, and about half of the room is, kind of with me on that, the youngsters, to see the pendulum swing pretty radically one direction and radically the other. Arnie Steinberg there remembers that this used to be Reagan country, right? And California ain't so close to that right now. Yeah. So the question is whether the good sense of the American people will see a pendulum that has swung too far once they start seeing the consequences of that and start pulling it back the other direction. I suspect the answer is going to be yes to that. But, it's a little too early to tell. Sometimes pendulums swing so far they get stuck over there. The notion of the pendulum swing on using the impeachment power to get rid of judges who use the bench to implement legislative policy. That swung over when they tried to do that in 1803, and it's stuck there ever since. So I think it's an open question yet whether this pendulum sticks or whether it starts coming back our direction. I remain optimistic in the good sense of the American people. Once it may require that they see the consequences to be so bad and then some before it starts swinging back. What is it Churchill once said? They'll get to the right answer eventually after trying all the others. But I think that's where we are.
I mean, I think you asked a really deeply important question, whether the kind of values that the court has been pursuing over the last 20, 30 years are somehow at odds with the policies that we know or the values that we know lead to a healthy society. And you see that being fought out all over in our society, lots of different institutions now. Maybe federalism provides some solace, though. That's the subject of our panel. If there are, the ability to choose different policies and people can move to those states, if there are a lot of Americans who want to live, implement Marxist economic policies, then they can all collect themselves in Vermont and perhaps elect a Marxist to the Senate. Has that happened? And if you want to have, capitalists can all go to someplace like Texas and have, less, So you could have, at least in the area of economic policy, I think the diversity of provided by federalism allows for a country that can have serious disagreements about social values, about rights, to create different communities within the country and choose to live where you want to live, which it has the values that you want, or for us to learn from the failures of other jurisdictions that try that. You could say, look at what we're doing in California. I mean, we're engaged in this, this economic experiment that I think is just going to collapse. I don't know how we're ever going to get out of it. But those lessons that other people will draw from us in other states will, be good for the country, I hope. And people can leave California and move to these other states where maybe we don't have such a large government sector and such high taxation.
I guess I'll just say something very quick, which is that I guess I disagree with the premise of the question as to whether there is an eclipse of values. And even if there was, it's unclear whether there is enough of a shared version of fundamental values so as to make that claim. And I think people have serious disagreements about that, and that is the point of having a pluralistic society and structural allocation doctrines like localism and federalism that allow for those disagreements to be heard.
All right. Over here. Where's the microphone?
Thank you. I was very struck by Professor Yu's critique of the levels of scrutiny, which seemed, I agree, are kind of arbitrary. And I was just asked the question, would it be more constructive to look at this through the lens, these rights through the lens of the right of privacy? As conservatives don't really look at that right, I think, sufficiently. Libertarians do, but we saw it articulated in Griswold versus Connecticut for the first time expressly. And we've seen it to some extent in the marijuana laws, where we invoke the right of privacy as the right to ingest whatever you want to ingest in your own body. I would think it would also be invoked in the question of gun ownership, or right to keep and bear arms, as a right of privacy. The right of self-defense, is, you might say, is the apotheosis of the right of privacy, the right to defend your own body. So would invoking and looking at these various constitutional rights under the First, Second, Third, Fourth Amendment, et cetera, would it be better to look at it through the framework of how the right of privacy is implicated, rather than through some hierarchy of scrutiny?
I think Eastman planted that question.
No, I didn't. No, I didn't.
Go ahead.
Oh, you want me to take it?
Why don't you go first?
I mean, here's the difficulty, and it's a difficulty that's kind of flowed out of grandiose language in the 14th Amendment. Due process, equal protection are so fluid in their precision that it's allowed the courts to pour into those vessels whatever they wanted. And I think there's a similar concern with privacy. I mean, when I can make something as public as going to a medical facility to get an abortion as part of a right to privacy, that just shows that the privacy right itself is not nearly confined enough to operate as any constraint on judges who don't feel bound by the actual text of a constitution. And so I'm always afraid of these amorphous clauses giving more authority to judges to just be freewheeling. And I think that word has become particularly divorced from any of its original moorings in the law. You know, you look at Blackstone and the right to privacy and the protection of home and all those things. It's now just an unmoored concept into which creative judges, or even less than creative judges, can pour almost anything they want into it, and that seems to be a big danger.
I would actually say you're too narrow by limiting it to privacy, because I think the deeper question is, should conservative judges, well, liberal judges already agree this is fine, conservative judges look outside the constitutional text to identify rights that they're willing to enforce? Right? So why just call privacy is really referring, I think, in your question, to a whole lot of other clusters of rights. And so, they have, Justice Scalia's opinion in Heller really does depend on the idea that there is this unenumerated, non-textual right to self-defense that exists under natural right theory. And the Second Amendment's text, even though it only appears facially to protect the right to a militia, must presuppose that right to self-defense, or it doesn't make any sense. So even Scalia, the great textualist who fought most of his career against the Warren Court's creative interpretation of unenumerated rights, had to reach to. So to me, I think the way to reconcile that with your question is that this is still giving force to the original understanding of the people who wrote the Bill of Rights and the people who wrote the Reconstruction Amendments. If they imported into that language a certain vision of natural rights, then as faithful implementers of the decisions they made, we have to give the terms, those terms force by reaching outside the text in some cases. And I think the court, the last thing I say is, I think the court in some ways is in agreement with you, because if you look at least its decisions with regard to new technologies, they have been steadily expanding the right of privacy, but in a very undefined, I think, and clumsy and unthought out way. So you think about the cases about the GPS tracker, right, the cell phone locational data. Another one where Scalia, I think, also kind of reached outside text, the heat detection devices. These are all areas where traditional doctrine would have probably said all of those law enforcement techniques are legal and don't need a warrant. But the courts identify, finally in this case, Carpenter, they admitted, oh, all these new technologies and the aggregation, accumulation of everything government knows about you somehow intrudes on your rights, even though Chief Justice Roberts can't identify specific constitutional text that's violated. He's presupposing there's something else behind that text which the government can't get at using these new technologies. But he has no theory of it. It's not thought out. It just sort of pops up every time they get this new case involving the latest technology. I think there's more work. More importantly, the conservatives, I think, have an obligation to try to identify what that is and how we would figure out how to interpret it, but in a way that's still limited, so it's not just freewheeling, policy preferences by the judiciary.
Deep, you want to say a word?
Yeah, sure. I'll say, that thinking through whether there are natural rights and whether certain provisions of the Constitution simply recognize those pre-existing natural rights. And it's not really the way in which I think about the Constitution, but even if we did, right, and I know, John, you've written about the Second Amendment being one of those natural rights, it's not clear to me that still answers questions about what to do about modern-day state and local regulation. So it's not clear to me just because we know that the Second Amendment's right to defend oneself is a natural right, even if we accept that methodology, whether that tells us whether a state or local regulation that says you can't have a magazine of 14 bullets versus 12 versus 10 is legal or not legal. So I guess I'm not here to dispute whether one can think about it that way. I'm just not sure it provides us concrete answers.
All right, Mr. Pallon down there.
Yes, continuing with this issue of the right to privacy and Griswold, which I generally support, it's always struck me that the liberal concern with privacy, usually correct, except in abortion cases, which are very different cases, seems to end when it comes to private association and the right to freedom of association. And it leads ultimately, of course, to our anti-discrimination law gobbling up the freedom of association. And is there therefore any way out of this, if we're going to, any way to avoid judges making these value judgments, as in the cake shop case, if we're going to have a full-throated anti-discrimination law, and is there any end to the criteria that can be used to ensure that you not be discriminated against?
Well, I mean, it seems to me the one answer is the one that Richard Epstein famously gave in his book, Forbidden Ground, when he said all of these anti-discrimination statutes that reach private conduct are unconstitutional. We ought to be looking at state action. Nobody's going to go that far. The lunch counter discrimination in the South is a quintessential example of something we're not willing to tolerate as a society, and I think rightly so. But when you go beyond that most egregious example and use that not as an anomaly but as the model, then you get a real problem, particularly when we become such a society with so many diverse views about controversial things like sexual orientation and marriage, and the very definition of marriage that's been around since time immemorial. Now, in the space of 10 years, even adhering to that position makes you such an outlier that you get speeches canceled. I mean, this is, right? And so I think we've got to get back to closer to where Richard Epstein had set out. And the freedom of association, how many businesses had to sign up? I reserve the right to refuse service to anyone. Right? If I don't like the way you smell when you come into my restaurant, I don't have to let you in here. If I don't like the fact that you're not wearing a shirt or shoes, I don't have to let you in here. If you want to compel me to help you celebrate something that I find morally offensive, why should that rule be different if the thing I find morally offensive, the state doesn't? Same-sex marriage, and the thing I find morally offensive, the state also does, a KKK Klan rally poster at a Kinko's, right? I mean, these are both exact cases. And the same commission in Colorado came down on the opposite side. One because it agreed with the viewpoint, and the other it didn't. And if we don't expand the space to have disagreements about those things, it's not just a freedom of association problem we have. It's a freedom of speech. It's the right to contest the status quo that's being imposed by government. And then we're no longer free. And so somewhere between the lunch counter and those cases, we have got to find a different middle ground.
Okay, folks, it's 12:15, and that's the end of our panel discussion. Please join me in a hand for our